to consider how UK businesses can start preparing for the post-Brexit era. We know that a lot is about to change, but is there anything that you can be doing now to prepare for those changes? The first thing I would say in terms of preparing for the post-Brexit era is make sure you know and understand your current workforce. So if you have a high percentage of EU nationals in the workforce, or you have EU nationals in certain business critical roles, make sure that they're aware of the requirement to make an application under the EU settlement scheme before the 30th of June 2021. Because if they don't make their applications in time, then there is a risk that they will lose their longer term rights to continue living and working in the UK. In terms of those applications under the EU settlement scheme, we would advise that, if appropriate, you support employees with their applications, you notify them of the requirement to make an application, and you provide supporting documents if required. But what we don't advise is that you ask EU nationals to bring in evidence that they have made an application under the EU settlement scheme, because under the current guidelines by the government, there is no requirement on an EU national to prove their status under the EU settlement scheme until the 30th of June 2021, requiring EU nationals to produce evidence of their status under the EU settlement scheme before that date would actually amount to discrimination. And therefore what we're saying is advise and support employees with their applications. If somebody brings in evidence that they have made an application to show to you, then that's fine, but don't start asking employees for evidence of their status under the EU settlement scheme at this time. Even when the requirement to produce evidence under the EU settlement scheme comes in on the 30th of June 2021 under the current proposals, at the moment there is no suggestion that that requirement will apply to existing workers within your workforce. It will only apply to new recruits as things currently stand, and therefore again, any suggestion to EU nationals who are already members of your workforce that they have to prove to you their status under the EU settlement scheme may well fall foul of discrimination legislation and therefore should be avoided. The second thing I would say in terms of your existing workforce is prepare for a degree of uncertainty during the Brexit transition period. So it may well be that the individuals within your organisation who are responsible for recruitment, who are responsible for right to work checks, for example, are not clear on what the rules are, for example, for individuals who come into the UK for the first time during the transition period. And therefore make sure that the relevant stakeholders within your organisation are aware of what they need to be doing in terms of right to work checks for these individuals and what their status is under the current regime. There is a risk that if EU nationals are asked for the wrong documents, for example, during the recruitment process, then they could bring claims of discrimination against the organisation. The next thing I would say in terms of preparing for the post-Brexit era is start thinking about sponsor licences. So, as we have heard in a previous section, under the current regime applicable to non-EU nationals, they are only able to come into the UK for work-related purposes if they are sponsored by an organisation that holds a sponsor licence issued by the government. And as we know, one of the changes is that that system is going to be extended to EU nationals from the 1st of January 2021 onwards. And the government policy statement, which was issued in February of this year, clearly states that employers not currently approved by the Home Office to be a sponsor should consider doing so now, i.e. the government is now actively encouraging those organisations who don't already hold a sponsor licence, perhaps because so far they've only really needed to recruit from within the UK and the EU and therefore haven't needed one. The government is now actively encouraging those organisations to start preparing their applications for sponsor licence now in order that they are ready to start recruiting from within the EU from the 1st of January 2021 if they need to. In terms of making an application for a sponsor licence, the most important thing to do is to prepare your business case as to why you need that licence. And preparing that business case could involve analysing your current workforce demographics to see what percentage of EU workers you currently have, thinking about how many EU nationals you think you will need to recruit from the 1st of January 2021 onwards, looking at where you've recruited from in recent years. If you've done a lot of recruitment directly from the EU, then clearly your argument for needing a sponsor licence in the future is going to be stronger if there's a likelihood that those recruitment needs will continue into the future. Think about where the gaps are likely to be in the workforce going forward and where you think those gaps are most likely to be filled from, i.e. is the local resident UK workforce sufficient to fill the gaps that might be created by the lack of EU labour available, or will you need to go out and fill those gaps from within the EU or beyond the EU? And it's important that you present the strongest possible business case you can for that sponsor licence, because if you make an application and the application is refused or rejected on certain grounds, then in certain circumstances, a cooling off period of 6 months applies before you're eligible to make a further application. And therefore, you could find yourself in a position where the business has a need to recruit either from within the EU or beyond the EU, but you're caught in this cooling off period and can't actually proceed with that recruitment because you can't make the application for a sponsor licence. The other thing worth bearing in mind in terms of the sponsor licence application is that at the moment, the Home Office states that an application should be dealt with within 8 to 10 weeks. In practice, we're finding that currently sponsor licenses are being turned around quicker than that, and we've had applications successfully being made within a 4-week period. But I think the closer we get towards the end of the transition period, and the closer we get to the period where organisations realise that sponsor licenses are going to be required for the recruitment of EU nationals from the 1st of January onwards, the more applications we're going to be seeing and the longer the waiting period is likely to be before the applications are considered. And therefore, it really is worth thinking about putting those applications in now if there is a strong likelihood that you will need EU workers from the 1st of January onwards. The other thing to bear in mind in terms of the sponsor licence is identifying the key personnel. So we've heard in a previous section that there are certain roles that have to be held under the sponsor licence, and it's worth thinking about who within your organisation is the appropriate person to hold or the appropriate people to hold those roles now. So again, once you're ready to make the application, those decisions have already been taken. And the other thing that's quite important is to train your staff on the various duties and obligations that come with holding a sponsor licence. The fact that there are some onerous and stringent obligations that come with holding a sponsor licence. If those obligations aren't met by the sponsor licence holding entity, the licence can be revoked and the ability to continue sponsoring migrant workers can come to an end. And therefore, it's important that whether you have an existing sponsor licence, but actually it's not something you've had to engage with too often because you've only used it for very limited recruitment from outside the EU in the past, or whether you're applying for a licence for the first time, it's important that the staff who are responsible for the management of that licence are fully aware of the obligations and duties that come with that licence, particularly in respect of notification to the Home Office of various events, and making sure that the Home Office is kept up to speed with any key events regarding migrant workers. The other thing that's worth bearing in mind in terms of sponsor licences is if you already have an intra-company transfer licence, which enables you to bring employees from group companies outside of the UK into the UK for work, then the likelihood is that at the moment EU group companies aren't going to be named on that sponsor licence as being entities that are linked by common ownership and control from whom you can transfer staff, simply because so far there has never been a requirement to sponsor EU workers to come into the UK. And therefore, now might be a good time to start thinking about linking any EU group companies onto your intra-company transfer sponsor licence, again to make sure that when the changes hit from the 1st of January 2021 onwards, you're in a position to bring people in to the UK from EU sister companies if you need to immediately. The other thing that you can be sensibly doing now in terms of preparing for the post-Brexit era is to start having a look at your existing right-to-work policies, making sure that they are generally legally compliant, and in particular, making sure that they reflect the changes to right-to-work documents that will be required in respect of EU nationals from the 30th of June 2021 onwards. It's important that you don't start asking existing EU workers to provide updated right-to-work evidence in terms of their applications under the EU settlement scheme, because at the moment there is nothing from the government which suggests that the requirement to prove status under the EU settlement scheme will apply to existing workers. It will apply to new recruits only as things currently stand. You might find as well that when you are recruiting new EU nationals, there is a slight question mark as to the legal status of EU nationals who arrive in the UK between the 1st of January 2021 and the 30th of June 2021, bearing in mind that under the current proposals from the government, only EU nationals who were already in the UK before the end of December 2020 have a right to make an application under the EU settlement scheme. But at the same time, as employers, you can only ask EU nationals to prove their status under the EU settlement scheme from the 30th of June 2021 onwards. And therefore, at the moment, there is this question mark over this 6-month period between January and June. And if you are recruiting an EU national during that period, then under the current rules, the right to work checks applicable to them are simply a passport or a national identity card, but there is no way of you as an employer knowing whether that individual will have the right to make an application under the EU settlement scheme, or whether in fact they will be subject to the points-based system from the 1st of January 2021 onwards, because they're not eligible under the EU settlement scheme. So there's a bit of a legal loophole there, which hopefully the government will close and clarify. But again, it's one of those watch this space areas, and it's an area in which there might be updated guidance at some point. The other thing your business can be doing now is thinking about future workforce planning. So if as a business you know that you are going to be recruiting from within the EU from the 1st of January 2021 onwards, consider whether it's possible to bring that recruitment forward into 2020 before the obligation to sponsor EU workers kicks in and before the costs associated with sponsoring migrant workers kick in for EU nationals. If it's not possible to bring the recruitment of EU nationals forward into 2020 and you are going to be recruiting from January 2021 onwards, then make sure that the business is aware that for the first time there are going to be costs and procedures involved in recruiting from within the EU which haven't been there in the past. So we've already heard in a previous section about the costs associated with recruiting under the existing points-based system. So we know that the immigration skills charge of up to £1,000 a year applies currently to non-EU workers, that there's an immigration health surcharge of £620 a year for adults and £400 a year for child dependents. And whereas these costs haven't so far applied to EU nationals, they will apply to the recruitment of EU nationals going forwards, which was once a cheap process into a potentially very expensive one going forwards. If you have British staff working in the EU who are going to be required to make residence applications in the EU member state they're living and working in, then it might be a good time to start speaking to those individuals about the requirements that they will be subject to and potentially providing them with assistance if required. Similarly, if you know that you are going to be moving British staff into the EU from the 1st of January 2021, now might be a good time to start taking legal advice in the country to which you're planning on moving them to in terms of what the immigration requirements are likely to be for those individuals and what applications need to be made before they can be lawfully recruited to live and work in another EU member state. And there are various practical issues to consider when it comes to British staff moving to the EU for work from the 1st of January 2021 onwards. For example, various EU countries require that the individual's passport be valid for 6 months after the end of their trip. That's a new requirement that hasn't applied so far. You might need to think about travel insurance for the individual, health insurance, ensure that their professional qualifications will be recognised in the EU member state, and think about things like driving licences. So will their UK driving licence need to be exchanged for a local licence if they're going to be in the EU member state for a considerable length of time. The other thing that you can be thinking about now is where will the skills gap be for your organisation? So we already know that the freedom of movement of EU workers is going to end. EU workers aren't going to be able to come to the UK to do low-skilled, low-paid roles anymore. They will only be able to come to the UK to do work which is considered sufficiently skilled and which pays at the minimum salary thresholds. And this, we know, is likely to create a skills gap in certain sectors. Start thinking about where you think that skills gap will be within your particular organisation. We've already seen that the government has proposed in its recent policy statement that employers need to be concentrating on investment in technology and automation. So start thinking about whether it is possible to invest in technology and automation and whether these could be used to plug the skills gap within your organisation once EU nationals are no longer going to be able to come to the UK to work so freely. If you're an organisation that relies heavily on agency workers, then now's a good time to start liaising with those agencies to make sure that they have sufficient contingency plans in place if they in turn rely heavily on EU workers. Because what you don't want to find is that your supply of agency workers dries up because the agency hasn't done any forward planning or hasn't done sufficient forward planning to think about how they will bridge the gap in terms of EU workers going forwards. Another thing that's definitely worth thinking about at this stage is minimising the turnover of existing staff. What we do know is that if you are going to lose staff and those staff are going to be replaced by EU workers coming into the UK for the first time going forwards, that's going to be an expensive, time-consuming process. And therefore, in the long run, it may well work out to be significantly cheaper to invest or look at things like existing salaries, benefits, working arrangements, and see whether there is anything that can be done around these things to retain existing staff rather than having to replace them with EU or non-EU nationals going forwards. And if you think the skills gap in your organisation is likely to be at a more junior level, then start thinking about apprenticeships and whether you can engage apprentices to fill the gap at a lower level within your organisation if that's not something you've ever engaged with before. The other thing that is quite important to say at this stage is it's vital to keep up to date with developments in this area. We're still in the Brexit transition period. We're still in a period where trade negotiations are very much at their infancy with the EU, and therefore we're still at a stage where things could change and could progress. In particular, it may well be that the government introduces concessions to the points-based system and to the various skills thresholds and possibly salary thresholds, which impact upon individuals your organisation might need to recruit, and therefore it's important to keep up to speed with how things develop in terms of the skills level and the various categories of workers that are going to be considered to be highly skilled enough to come into the UK under the new points-based system from January 2021 onwards. We obviously will be publishing our own updates as the position becomes clearer and as we get further guidance from the government, and therefore if you're not already signed up to the Walker Morris updates, now might be a good time to start thinking about signing up for those to make sure that you can be kept abreast of changes.